No one anticipated that Supreme Court Justice Barrett would directly confront Elon Musk during that highly publicized hearing. The courtroom fell into a profound silence as Barrett turned sharply toward the tech magnate, her tone resolute and commanding. "Mr. Musk, your actions exhibit a repeated disregard for well-established legal precedents," she stated with unwavering firmness, sending a visible shiver through everyone in attendance. But what followed would stun not only Justice Barrett, it would leave the entire judicial panel speechless. As we go on, make sure to subscribe to the channel and like the video. Instead of backing down or showing even a hint of intimidation, Elon Musk remained composed, almost serene. Calmly, he reached for a folder resting in front of him, a folder that would soon flip the entire trajectory of the trial. What had been framed as the lawsuit that might finally humble the richest man in the world was on the verge of becoming a dramatic reversal, with the accusers themselves unexpectedly on the defensive. If you want to witness brilliance unfold in real time, follow every turn of this gripping account. And don't forget to like and subscribe, because what the mainstream media won't show you is often where the real story begins. The stakes couldn't have been higher. The case Federal Communications Commission versus X Corp had climbed all the way to the Supreme Court after months of mounting pressure. At the center of the dispute, accusations that Musk's social media platform had violated federal communications regulations by refusing to comply with specific content moderation protocols. Justice Barrett, appointed by former President Trump and widely regarded for her strict constitutional interpretation, had carved out a unique reputation, respected across ideological lines for her razor-sharp legal intellect and unwavering commitment to the rule of law. That day, Elon Musk sat at the defendant's table dressed in a plain dark suit and a deep blue tie. Understated, no theatrics. His legal team surrounded him. Yet unlike most defendants who let their lawyers do the talking, Musk had insisted on speaking for himself. Analysts had already called this a risky move, a display of either supreme confidence or bordering arrogance. The case against him had, until then, appeared ironclad. For months, headlines had circulated detailing alleged regulatory breaches by X Corp. Legal pundits filled TV panels, confidently predicting heavy penalties. The FCC had compiled a mountain of what they called irrefutable documentation, alleging repeated violations of newly updated rules. "This isn't just about policy," the Attorney General had declared in his opening remarks. "It's about proving that no company, regardless of its size or the net worth of its owner, is above the law." What no one outside Musk's inner circle knew, however, was that he had spent nearly a full year preparing for this showdown. Immersed in constitutional law, analyzing case history with the intensity of a seasoned litigator, he was about to leave even the most skeptical legal minds astonished. Justice Barrett began her questioning with her signature surgical precision. The courtroom was packed with journalists, legal scholars, and spectators lucky enough to secure a seat for what was already being called one of the most consequential Supreme Court cases in decades. "Mr. Musk, your platform has repeatedly ignored formal requests to comply with the modifications outlined in Section 230 of the 2023 Communications Reform Act," she declared, her voice firm but calm. "Can you explain why you believe your company should be exempt from the standards that apply to every other communications provider?" Musk leaned slightly toward the microphone. His tone was respectful, yet resolute. "With all due respect, Justice Barrett," he began, "that's not accurate. We have never claimed to be exempt from any legitimate law." Justice Barrett's gaze narrowed, her expression laced with skepticism. "Your conduct reflects otherwise. The record shows 17 formal notices. Actually, 16, Musk calmly corrected. Barrett's brow furrowed. "Excuse me? There were 16 notifications, not 17, Musk repeated evenly. And we provided a legal response to each one, grounded in firmly established precedents." Barrett flipped through her papers. The official record states, "The file submitted by the FCC is incomplete." Musk interjected, something nearly unheard of in front of a Supreme Court justice. A ripple of murmurs spread across the room. Chief Justice John Roberts looked poised to intervene, but Barrett raised her hand, signaling she would handle it herself. "Mr. Musk," she said, her tone sharp, "this court has little tolerance for technical quibbles that sidestep the heart of the matter. What we're observing here is a repeated pattern of regulatory defiance." But Musk stood his ground. "With respect, Justice, what the FCC calls noncompliance is, in fact, our consistent effort to remain within constitutional bounds." He opened the folder in front of him. "And I believe this court will want to examine the evidence showing that the FCC has deliberately misrepresented our position." The air thickened with tension. Justice Sotomayor exchanged a glance with Kagan. Justice Alito leaned forward, clearly intrigued. Barrett's eyes locked on Musk's. "You're suggesting this court has been denied access to key information?" "I'm not suggesting," Musk said. "I'm stating it plainly. The petitioners intentionally withheld relevant data from this court." The Solicitor General abruptly stood up. "Your Honors, that's a baseless and outrageous accusation." Barrett cut in sharply. "Mr. Musk, the allegations you're making are extremely serious. Without undeniable proof, they could significantly harm your credibility before this bench." Musk remained composed. "I fully understand the gravity, Justice Barrett. That's precisely why I've brought documents demonstrating that the FCC's regulatory demands violate at least 3 prior Supreme Court rulings, including one where you authored the majority opinion." A louder stir swept through the courtroom. Those familiar with Barrett noticed the faintest shift in her expression. "Which precedent are you referring to?" she asked. "Net Choice v. Paxton, 2024, Musk replied. "In that decision, you emphasize that federal agencies cannot compel private platforms to adopt content policies that, in practice, amount to indirect state control over speech." A heavy silence fell. No one had anticipated this kind of argument. Justice Clarence Thomas, who had been silently observing, finally spoke. "Mr. Musk, are you asserting that the FCC's directives fall precisely under that category?" "Yes, Justice Thomas. And I prepared a detailed analysis to illustrate exactly how." The FCC's lead attorney stood again. "Your Honors, Mr. Musk is not a legal scholar. His interpretation of Justice Barrett's ruling is misguided and opportunistic." But Barrett was already flipping through the documents Musk's team had submitted to the clerk. Her face gave little away, but it was clear she was studying them closely. "Is the government disputing the authenticity of these communications?" she asked, directing her question squarely at the FCC attorney. He hesitated, a clear sign of uncertainty. "We would require more time to thoroughly examine that, Your Honor." That's when Justice Barrett did something unexpected. She turned directly to Musk. "You came prepared for this specific line of inquiry, didn't you?" It wasn't really a question, more of a statement. But Musk answered anyway. "Yes, because the constitutional principles at stake go beyond my company. What's at issue here is whether federal agencies have the authority to use regulatory mechanisms to achieve ends that would be unconstitutional if pursued overtly." The atmosphere in the courtroom shifted immediately. What many had assumed would be a public reprimand of a defiant billionaire was rapidly turning into a high-level constitutional debate over the reach of government authority. Known for her piercing scrutiny, Barrett continued. "Even if we accept your argument regarding the FCC's intent, X-Corp still ignored valid court orders while preparing this challenge. That's not how our system works, Mr. Musk." He responded without hesitation. "Actually, Justice Barrett, in Youngstown Sheet and Tube Company v. Sawyer, the court made it clear that when confronted with potentially unconstitutional directives, the affected party is permitted to seek judicial review before compliance, especially when there's a risk of irreparable harm. We filed for injunctions in 3 separate circuits while simultaneously preparing our legal response." Barrett's surprise was subtle but noticeable. This wasn't just a CEO defending his business. There was deep legal acumen behind every word. "And those injunctions were denied," she noted. "Yes, but not unanimously. The decisions were split. In fact, Justice Jackson, in her dissent at the D.C. District Court, argued that the constitutional issues presented were substantial enough to merit review by this court. The government's legal team attempted to regain control. Your Honors, Mr. Musk's theoretical framework doesn't change the fact that X Corp repeatedly violated clearly established federal guidelines. But Barrett, now visibly more engaged, interrupted. The constitutional validity of those guidelines appears to be the core question here. Mr. Musk, please proceed. What followed would dominate headlines, social media, and academic panels for weeks. Elon Musk, standing before the highest court in the land, delivered what many would later call a masterclass in constitutional law. Even skeptics were caught off guard. Justice Barrett, I would draw the court's attention to page 47 of the binder we submitted. These are internal FCC communications obtained through FOIA requests. They demonstrate a coordinated effort by the Commission to bypass the limitations imposed by the decision in NetChoice v. Paxton. Barrett scanned the documents, and her expression grew increasingly serious as she read. These appear to be official FCC memos. They are, Your Honor. If you examine the highlighted section, you'll see a remark from Commissioner Thompson. Though Justice Barrett's opinion restricts our direct authority over content moderation, our technical compliance regulations provide us an alternative path to reach the same outcome. A low murmur spread across the chamber. Other justices flipped through the pages with focused intensity. Barrett lifted her eyes, gazed sharp. Mr. Solicitor, do you have a response to this? The government's lead attorney looked uneasy. Your Honor, without full context, isolated excerpts like these may lend themselves to misinterpretation. The FCC's regulatory actions were carried out in good faith and intended to serve the public interest. Musk cut in before the solicitor could respond. You'll find the context on the following pages, he said. There are transcripts from FCC meetings where officials openly discuss using technical regulations as a useful pretext. Their words, not mine, to coerce platforms into adopting moderation policies that this very court has already deemed unconstitutional. Justice Barrett turned toward the government's attorney. We'll need clarification regarding these materials, counsel, and if I understand correctly, they weren't included in the lower court filings because the FCC itself requested that they be sealed. Musk followed up before the lawyer could reply. We only gained access to this information 3 weeks ago through a finalized FOIA request in the Ninth Circuit. Justice Alito leaned forward, his voice firm. Are you implying there was a deliberate attempt to withhold this evidence from the judiciary? The facts speak for themselves, Your Honor, Musk replied calmly. The FCC was fully aware that its policies clashed with this court's ruling in NetChoice. Instead of adjusting their approach to comply, they chose to circumvent it. At this point, Barrett was clearly engrossed, not only by the documents before her, but by Musk's line of reasoning. Her earlier skepticism had evolved into measured attention. Mr. Musk, she said, you're not just referencing precedent here. You're suggesting that the FCC employed regulatory workarounds to achieve ends prohibited by the Constitution. Precisely, Justice Barrett, and not just any unconstitutional ends, but actions specifically barred by your own majority opinion, delivered less than a year ago. The weight of that moment was unmistakable. Barrett, who had begun this exchange demanding accountability from Musk, was now listening with authentic interest. Your Honor, Musk continued, I'm not a trained attorney, but in preparing for this case, I've spent countless hours immersed in constitutional law. And when I studied your opinion in NetChoice, I realized we weren't just dealing with overreach. We were facing a fundamental violation of the First Amendment. He then quoted directly from Barrett's own writing. When the government employs regulatory authority to indirectly achieve what it is constitutionally forbidden from doing directly, the courts have a heightened duty to intervene. A profound silence filled the courtroom. Barrett looked at Musk, reassessing the scope of what was unfolding before them. This isn't about technical compliance, Musk pressed on. These FCC directives were crafted to force moderation policies that would suppress specific viewpoints. The internal memos prove it was premeditated. Barrett nodded slowly. Then she asked the question that would redefine the hearing. Mr. Musk, if your interpretation is accurate, why hasn't any other platform challenged these directives on constitutional grounds? The answer is simple, Musk replied. Fighting the federal government takes more than legal standing. It takes resources and resolve that most companies simply don't have. The path of least resistance is to comply, even if that compliance infringes on constitutional rights. Fortunately, I had both the means and the conviction to stand against what I saw as an abuse of regulatory power. Barrett made a brief notation, then looked back up. Her voice had shifted, measured, but noticeably changed in tone. Your legal reasoning is far more compelling than I expected, Mr. Musk. Coming from Barrett, renowned for her legal precision, that was no small statement. In fact, it was a rare and remarkable compliment. The Solicitor General made one final effort to push back. Regardless of Mr. Musk's arguments, the undeniable fact remains. X-Corp failed to comply with orders lawfully issued, orders that every other platform followed without resistance. But Barrett didn't let it slide. If those directives were, as these documents suggest, merely a facade for unconstitutional goals, she said, then widespread compliance doesn't prove their legitimacy. It only reveals the chilling effect that unchecked regulatory authority can have on constitutional freedoms. In that moment, the government's case began to unravel, right before the eyes of the nation. What was originally framed as a model prosecution of a defiant billionaire was rapidly morphing into something far more profound, a landmark inquiry into the overreach of federal authority. Justice Barrett turned once more to Musk. To be precise, Mr. Musk, your claim is not that X-Corp refused to comply with lawful regulations, but rather that it rejected unconstitutional government coercion masquerading as regulatory policy. Exactly, Your Honor, Musk replied, and we have meticulously documented every step of our constitutional objection, even while the media painted us as nothing more than rebellious lawbreakers. Barrett exchanged glances with her fellow justices. Her expression suggested she understood the weight of what was unfolding. This wasn't just about the future of a single tech company. It was about the balance of power between the state and private enterprise. Chief Justice Roberts finally spoke. It appears we'll need to examine these documents in full detail. Counsel, the court expects a comprehensive explanation. Musk's success wasn't just in defending his company. It was in reframing the entire nature of the proceedings. With rigorous preparation and an unexpectedly sophisticated grasp of constitutional law, he had turned the case on its head. 3 days later, the Supreme Court issued a rare administrative injunction, an immediate suspension of any enforcement actions by the FCC related to the disputed guidelines, pending a final ruling. Legal analysts called the move a stunning validation of Musk's arguments. On CNN, commentator Jeffrey Toobin remarked, nearly in disbelief, "What just happened was extraordinary." Justice Barrett, who many assumed would be Musk's harshest critic, essentially affirmed the core of his argument. "I've covered this court for years. I've never seen anything like it." The reaction exploded across social media. Hashtags like hashtag #MuskleGenius and hashtag Barrett versus Musk began trending globally. Clips and courtroom sketches flooded X, formerly Twitter, with some scenes even adapted into animated reenactments for primetime news broadcasts. Supreme Court law clerks dissected Musk's every word in legal podcasts, with many admitting they had underestimated him. He cited precedents I had to look up, confessed a renowned Yale constitutional law professor. That level of nuance isn't something you expect from a non-lawyer. Meanwhile, Justice Barrett maintained public silence, adhering to judicial protocol. However, sources close to the court revealed that she had ordered a comprehensive review of all FCC internal communications related to content moderation over the last 3 years. The ripple effects were immediate and widespread. Other tech giants began re-evaluating previously uncontested directives from the FCC. Google announced it would reassess regulatory demands in light of the constitutional issues raised during the Musk hearing. Meta, formerly Facebook, filed a petition to formally join Musk's case as an interested party. Legal commentators started publishing op-eds suggesting the case might become one of the most significant First Amendment rulings in decades. Harvard Law Review fast-tracked a special issue, entirely devoted to the constitutional questions now swirling around the FCC's regulatory practices. What began as an attempt to rein in a billionaire was rapidly transforming into a historic confrontation over the very limits of governmental power and the protection of free speech in the digital age. The tension in the room became palpable as the government's case began to crumble. What was meant to be an exemplary action against a defiant billionaire was turning into a historic case about the abuse of state power. Barrett turned to Musk with a direct question. Let me be clear, Mr. Musk. Your claim is that X Corp did not oppose legitimate regulations, but rather succumbed to government pressures disguised as regulations? She asked. Musk answered without hesitation. Exactly, Your Honor. And we have detailed records showing our resistance to these pressures, even when the media painted us as mere lawbreakers. As she exchanged glances with the other judges, Barrett seemed to realize that this case was about far more than just a company clashing with the government. It was a much larger issue of authority and constitutional freedoms at stake. Chief Justice Roberts then spoke. We need to carefully review all these documents. The court expects a thorough explanation. At that moment, the direction of the trial began to shift. What had seemed like a straightforward confrontation was becoming an ideological battle. Musk's preparation was impressive, and his stance wasn't just one of resistance. He was presenting a solid legal argument. Shortly after the hearing, a former FCC employee came forward as a whistleblower, confirming that there was indeed an internal plan to use technical regulations as a tool to control speech on platforms. The scandal quickly escalated, and Musk's reputation soared. Previously seen as a daring businessman, he was now recognized as a fierce defender of constitutional liberties with a remarkable legal acumen. He was even invited to give a lecture on constitutional limits at Stanford, and his case became studied as a notable example of fighting against government overreach. Though the case was far from over and a final decision would take months, it was clear that Musk had achieved a symbolic victory. The Supreme Court had issued an administrative suspension, blocking any actions by the FCC related to the contested guidelines. Many experts were already predicting that this case would become a landmark in defining the limits of government power concerning freedom of speech. During a press conference after the suspension, a reporter asked Musk, "Are you a lawyer?" Musk smiled slightly and replied, "No, but when fundamental principles are at stake, you learn what you need to know." He continued, "Justice Barrett, with her previous writings on government overreach, was my guide. I just followed the logic she herself had established." Musk's statement sparked waves of reactions. Many analysts recognized the irony in how the government, by trying to turn Musk into an example, had inadvertently had its own judicial philosophy used against it. Musk had challenged the narrative that he was just an irrelevant billionaire by cleverly using Barrett's own reasoning to expose what seemed to be an overreach of state power. The case continued, and over time, it became a fundamental reference in the digital age. Its resolution could redefine the boundaries between governmental power and freedom of speech, something few could have predicted when it all started with a simple dispute involving a major tech platform. If you like this incredible story, make sure to hit the subscribe button and like the video. Share it with someone you know will love it.